So the issue of concealed carry bans and the defiance of Bruen is once again in front of the Supreme Court. And now this has drawn the attention of the Trump DOJ, who is stepping in on concealed carry issues. So let's break down what is happening. Now, really quick before we jump into this video, I just want to mention that if you want to support the channel for free, please consider subscribing. Also click the notification bell and turn on all notifications, because that helps to ensure that YouTube will actually send you these videos. And then also just drop a positive comment down below, because that helps to tell the algorithm that you appreciate this type of two-way content, and it will share my video and other people's videos, that are related to the Second Amendment to more individuals. As I mentioned in the intro, in this video, we're going to be discussing how the issue of concealed carry bans in one of the ones out of New York is once again in front of the Supreme Court, and how this issue of the Bruen defiance by states like New York has caught the attention of the AG Pam Bondi and also the DOJ, who have now decided to step in on concealed carry. You may recall that the Supreme Court recently granted, vacated, and remanded the New York Antonyuk case back down to the Second Circuit for a new decision in light of what they said in the 8-1 Rahimi decision. The Antonyuk case challenged the state's new hyper-restrictive concealed carry ban, the CCIA law, which they passed just 8 days after the Supreme Court issued the Bruen decision. The Second Circuit issued its new decision on concealed carry bans, and they essentially just reissued the same decision, and they found that Rahimi did not change the outcome of their analysis at all. The Second Circuit still believes that a state like New York can place hyper-restrictive rules and restrictions on concealed carry and almost effectively ban concealed carry in the entire state. Now, in response to that, the plaintiffs have once again asked for the Supreme Court to review New York's carry bans, and at the same time this week, the DOJ put multiple states and localities on notice that their concealed carry bans and defiance of Bruen will no longer be tolerated under this administration. Now, this issue of concealed carry in New York has been a long battle, but really ramped up after Bruen. The New York CCIA law was challenged in multiple cases, and preliminary injunctions were granted to halt various aspects of that New York law. However, the state of New York was able to get the Second Circuit to reverse some of those preliminary injunctions. The Second Circuit ruled in favor of the state of New York, finding that the Bruen decision in the Supreme Court was an exceptional case, and its analysis really doesn't apply to their new law in the state of New York. Now, in response to the Second Circuit's ruling, GOA then filed a second petition for emergency Supreme Court intervention. Although the case was still in an interlocutory posture, meaning that it wasn't a final case, it wasn't finally resolved, but the Supreme Court did decide to GVR, meaning that they granted, vacated, and remanded the Antonyuk case back down to the Second Circuit in light of what they said in Rahimi. Now, after the Supreme Court GVR'd the Antonyuk case back down to the Second Circuit, you would think that the Second Circuit would kind of get the message and at least try to fake that they are faithfully applying the review in Bruen. But of course, that didn't happen. Instead, the Second Circuit wrote a 246-page opinion essentially saying that Rahimi changes absolutely nothing and that the Bruen analysis and the Rahimi analysis don't really apply to what's happening now in New York. But because of that egregious case and decision, now this is back in front of the Supreme Court. In the petition to the Supreme Court, GOA argues that repeatedly, the panel asserted that it was not bound to apply Bruen's methodology, surmising that Bruen was a case of exceptional nature, and courts maintain flexibility when examining less exceptional regulations. The panel repeated this claim no fewer than 4 times to justify circumvention of Bruen's framework. GOA goes on to state that if Bruen left any question unanswered, Rahimi laid that to rest. Contrary to the panel's insistence that Bruen was an exceptional case, warranting uniquely heightened historical stringency, Rahimi confirmed that Bruen simply explains the appropriate analysis. Thus, Bruen and Rahimi established the norm and do not permit a more nuanced approach whenever a court declares a challenged regulation to be less exceptional. This petition by GOA not only outlines the clear Second Amendment precedent that should have been followed by the Second Circuit there that really should have found that the New York CCIA law is in fact unconstitutional, but it also shows what lengths courts like the Second Circuit in states like New York will go through to defy Bruen and Rahimi. What is interesting about this case is that even though this is still in an interlocutory posture, it deals with a state law passed in direct defiance to what the Supreme Court said in Bruen. It also involves a court failing to faithfully apply Bruen and Rahimi even after this case was GVR'd by the Supreme Court. Even more interesting is the fact that the Supreme Court had set conference in this case for March 28th, so it was supposed to go to conference this last Friday. However, the day before the court was set to review and have this at conference, they decided to preemptively reschedule the case. When the Supreme Court reschedules a case, that case is moved on the court's docket from one of the justices' kind of private conferences to a later one before the justices even have the opportunity to discuss that case at conference. By contrast, a relist, which we see quite often, is when a case is moved from one conference to another, usually the very next one, but that happens after the Supreme Court already kind of got together and had the opportunity to discuss that case at conference. Now, what's interesting about this and the reschedule here in Antioch is it comes on the same day that the Attorney General and the Chief of Staff put out a notice to, all individuals in all states and localities within the United States that they are actively going to go after them if they continue to defy what the Supreme Court said in Bruin and continue to restrict access to concealed carry. In the statement of the Chief of Staff for the Attorney General, he stated that today the Department of Justice announced its first investigation of many, if need be, into whether states and localities, and then he said the Los Angeles County of California, are engaging in a pattern or practice of depriving ordinary, law-abiding Americans of their Second Amendment rights. As Justice Thomas has explained, the Second Amendment warrants the same respect as any other constitutional right. And also, as the Supreme Court has said, the Second Amendment is not a second-class right. But many states and localities keep insisting on treating the Second Amendment as a second-class right. California has been a particularly egregious offender. California Governor Gavin Newsom has bragged about having the strictest gun control laws in the country. Gavin Newsom even called for the 28th Amendment to restrict Second Amendment rights after recent pro-Second Amendment decisions by the Supreme Court. To make things worse, many California localities appear to be imposing additional burdens beyond those required by the state law, including by imposing excessive fees and lengthy wait times for concealed handgun licenses. This must end. Today, the Civil Rights Division announced an investigation into the Los Angeles County Sheriff's Department to determine whether it is engaging in a pattern or practice of infringing Second Amendment rights. So what this notice states is that the DOJ is going to directly go and investigate various states and localities for infringing on Second Amendment rights, specifically here when it comes to concealed carry. The notice states that they are specifically targeting the LA sheriff, that they're going to be going after and reviewing what they're doing with their restrictions on the access to concealed carry. The notice also says that they will investigate other states and localities if they get, wind that other states and localities are doing similar things and they don't voluntarily stop these type of delays. Also on March 27th, you had President Trump sign an executive order, and that was Thursday, same day that Antioch was rescheduled, and he says that he wants to expedite concealed carry permit applications in Washington, D.C. So when it comes to concealed carry and the defiance of Bruin, there's a lot going on right now, especially just all Thursday, a lot of this hit. The Supreme Court has rescheduled Antioch on that very same day that the Trump administration put out multiple notices to various areas saying that they're going to investigate them, and the same day that he put out the executive order saying that the Washington, D.C. area needs to expedite these type of applications for concealed carry. What this all indicates is that the Trump administration is taking the concealed carry issue very serious. That was one of his main, positions when it came to the Second Amendment when he was running for president, that he wanted national concealed carry reciprocity. He wanted more access to concealed carry. And it seems like they're going to activate the DOJ to investigate various localities and states that are not only just outright defying what the Supreme Court said in Bruin with the new laws that they passed in direct defiance to Bruin, but they're also going to be trying to put in place some things like national concealed carry reciprocity, trying to get Congress to do that. But they're also going to explore other avenues like executive orders when it comes to areas that they control, like Washington, D.C. So again, very interesting, some very cool developments when it comes to concealed carry. And it's nice to see that the DOJ is stepping in states like California and going after localities that are just outright denying Second Amendment rights and are trying to restrict the access to concealed carry. So we're going to be watching this closely to see, ultimately what's the fallout of this and how does this develop. Maybe some states and localities just kind of put up their arms and say, yes, okay, we're going to start issuing concealed carry permits the way that we should have directly after Bruin. Some states like New York and some cities like New York City and other states like California and LA County and San Francisco, I see that they're probably going to fight this. But this is a warning shot to a lot of those states and other states that, maybe are engaging in this conduct that they need to stop, or else they are going to have the DOJ going after them. So as we get more information, as things develop, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.